Hello and welcome to the Wire Talks. I'm Sidharth Bhatia. On January 26, India will celebrate its Republic Day, and as always, it will be marked by a grand parade in Delhi full of colorful state tableau, march past by defense personnel, and an impressive display of weaponry. Flags will be hoisted all over the country. But looking beyond all that pomp and circumstance, what does the day signify? This is the day in 1950 India became a republic and the constitution came into being. With that, universal adult franchise was introduced and a host of constitutional posts were also created. One of them was the post of the governor, and governors by and large have worked very well with their state governments, but of late governors have been in the news in several states and not for very positive reasons. Is it time to reevaluate this office and introduce some checks and balances? Is the constitution to blame or the individuals for going beyond their brief? Our guest today, Raju Ramchandran, is a good person to address those issues. Ramachandran is a senior lawyer in the Supreme Court with a distinguished record. He has been practicing for more than 45 years and was the additional Solicitor General of India in 2002 to 2004. He was appointed as amicus curiae, that is, the friend of the court, to assist the court in the Gujarat Riots case and also for Ajmal Kasab. Among the pending cases he is engaged in include the challenge to the scrapping of Article 370 and also to the electoral bond scheme. Raju Ramchandran, welcome to the Wire Talks.
Thank you, Siddharth. Thank you for having me.
So, tell me, Raju, looking beyond the pomp and ceremony, which is the hallmark of Republic Day every year, what exactly does the day signify?
It signifies the coming into the force of a republican constitution. And that is very, very significant. We chose consciously to be a republic. We chose the Westminster form of government. We chose a constitution with a fundamental rights chapter, a directive principles chapter. It is, of course, one of the world's longest constitutions, but it is also one of the world's best constitutions.
When you say one of the best, how would you qualify that? Because there are so many scores of democracies and even non-democracies have constitutions of some sort. Why would you say that?
I would say that because this constitution is elaborate. It makes provisions for a wide variety of situations which would have otherwise left scope only for conventions to play. Now also, of course, there is room for convention, but our constitution makers seem to have envisaged a variety of situations which the polity will have to face. Now, this has judicial review of legislation, which is something very, very important. It makes detailed provisions for the independence of the judiciary. It makes detailed provisions for other constitutional institutions like the Union Public Service Commission, the Election Commission, the Comptroller and Auditor General. So, if a constitution could be envisaged by the human mind to provide for liberties, to provide for a structure of governance, to provide for checks and balances, it is this constitution. And we should be legitimately proud of our constitution.
Now, rights and duties is something I'll be coming back to in later on. So it is an enlightened one, perhaps one of the most enlightened in the world. We were a new democracy in
That's right.
an independent country. And yet imagine the foresight of the people who worked on the constitution to say, I remember reading somewhere, memory may be a little hazy, that there was a lot of argument about giving the vote to only a certain segment, but they decided that it would be universal franchise from the beginning.
Absolutely.
And has given widespread rights to the citizens. Of course, there are duties. Do you think various governments have given sufficient emphasis to the rights part of it? Because I'm listening all kinds of people talking only about what our duties as citizens should be.
There's no government which would itself emphasize on rights. No executive will. The rights are meant for the citizens, and it is for the citizens to exercise their rights, and it's for the courts to ensure the exercise of those rights. Of course, the court in some judgments have said that the state has the duty to ensure enjoyment of rights. But it's not easy to visualize a situation where a government will proactively encourage the enjoyment of rights
And
by
they
citizens.
don't want citizens to get too much freedom. Is that it?
That's right. That's right. No, there's a constant tension between what they perceive to be the needs of a good administration and citizens exercising their rights.
Do you think that previous governments have actually gone out of their way to talk about rights? Let's talk about duties. I mean, again, this is in the air. All kinds of people have said that it's high time we concentrated only on the duties. Do you think this has been stated so upfront, so blatantly?
Well, if you remember, the chapter on fundamental duties was introduced by the Congress government during the emergency. So the concept of duties came in there. Later, duties may have faded into the background when there were less strong governments. But now that there is a very, very strong government, you find this emphasis on duties.
Yes.
Ask what you can do for your country, not what your country can do for you.
Oh, certainly.
A recycling of that. A recycling of that.
Certainly. When you said that there was strong governments, but then became weak governments, I would go as far as to say that the courts were also, in some phases, from the 70s onwards, post-emergency, very, very strong, very, very rights-oriented. And there were judges there was a famous case of a judge picking up a postcard and saying,
that's right.
Let's have a suo motu case on this.
Justice Bhagwati, that's right.
That's right, yes. So anyway, the whole narrative of the right duties have come back in the public domain over and over again. So many posts were established. You mentioned the Controller General. You mentioned the Election Commission, perhaps.
Yeah.
And that, to come straight to the point of our discussion today, one of them was that of the governor.
Yes.
Now, what was the original intention behind creating this office at that time? We would like a kind of detailed exposition on this.
Let me try to make it as simple as possible. This constitution was framed in the aftermath of partition. The country had just broken up. There was this strongly felt need to ensure that there wouldn't be fissiparous tendencies. And so the framers created a federal constitution with a strong unitary bias. You can have federal constitutions with a greater federal bias, but this is a constitution with a greater unitary bias. And so it was felt that there must be a governor in every state as the representative of the center and as a link between the center and the states. The Constituent Assembly debates would show that there was detailed discussion on how a governor should be appointed. There was a lot of talk about a governor being elected, either elected directly by adult franchise or indirectly in the way in which the president is elected. But then the framers thought that would create a parallel power center, a parallel political center of power. They didn't want that. So they decided that the governor would be someone who's appointed by the center. And that's how the post of governor was finally envisaged in the constitution.
Yes, and if I'm not mistaken, the governor is always from another state.
That's right. That's also to bring an element of detachment, to bring a different perspective, and to ensure that the governor in exercise of his or her powers is not swayed by purely local or parochial considerations. And so a convention, this is not a rule, the constitution doesn't say so, but this is a healthy convention which has developed.
Has over the years, were there checks and balances put on the role of the governor?
Checks and balances in terms of judicial interpretation, Yes, because the Supreme Court made it clear in the 70s itself, in Shamsher Singh's case, that the governor acts only on the aid and advice of the Council of Ministers. This was to set at rest any notions that the governor could exercise powers independently. So that check and balance has come through judicial interpretation. And the governor is left with a small area of discretion, an area where he has to act on his own, he or she has to apply independent mind. And it is important that that provision asking the governor to act independently or contemplating independent action by the governor, it's important that such a provision also exists in the constitution. And I could explain why. Now, in this federal constitution of ours, you have legislative lists. You have the union list, you have the state list, you have the concurrent list for legislation. Now, a state may pass a law in purported exercise of its power under a particular legislative list in the state list, but which would, in essence, be a matter which belongs to the union list on which only parliament can legislate. Now, it is in situations like this that the governor may either return a bill to the state legislature to reconsider, giving his objections, or send it to the president. Because when a serious question arises about the competence I use in a legal sense, of a particular state legislature to legislate on a particular subject which belongs to the union list, that's a matter which requires reflection. And therefore, you need a third party who will be the governor who will look at it. The governor who will look at it and then refer it to the president. So a governor who's not weighed by local considerations and passions, if he is part of the same state, he could be influenced by the same passions which influence the state legislature to pass the law irrespective of its legal limits.
So give us an instance of something like this which may have happened.
No, the instances are too many because the number of bills which have been reserved for the president's assent have been so many over the years. It's such a common phenomenon that I can't pinpoint one immediate instance to give you.
No, what you're trying to say, Raju, is that state governments will always try to push the envelope and go beyond their remit, in a sense.
Yes, not because they want to be confrontational, but because they believe, and let's grant them all that good faith, they believe that it's within their powers to legislate for their states. And you know, in constitutional law, there's something called the doctrine of pith and substance. So the state may legitimately believe that this comes within its remit. Then the courts have to examine, apply the doctrine of pith and substance and see what is the pith and substance of this legislation. Does it pertain to this topic under the state list, or does it actually in pith and substance pertain to that topic in the union list? So this is a delicate task of interpretation. However careful the constitution makers may have been in enumerating various subjects, there is always scope for some overlap. How much is that overlap? Does it only incidentally trench upon a particular subject, in which case it would not be unconstitutional? Or is it in pith and substance the other subject, because of which it would become unconstitutional?
So we'll be right back after this short break. Welcome back to the Wire Talks. So, but if the governor returns it once,
Yes.
one presumes, and one has seen instances of
Yes.
either the state government saying, okay, we will re-examine,
Yes.
possibility one,
Yes.
or say, sorry, this is all, you have to look at it again,
Yes.
in which case the governor passes it on to the president, because
Yes.
ultimately he or she reports to the president.
That's right.
But there is some room there for not a confrontation, but an argument
Yes, there is.
on both sides. But even the speech of the governor
Yes.
is written by the state government.
Yes. We are talking about particular speech. We are talking about a speech under Article 176 of the Constitution, special address by the governor on the floor of the House. Yes, that's right, to the House. Now, the governor can make an address under Article 175 also, which is the right of governor. to address and send messages to the house or houses. That's Article 175. But the context in which I think you're asking your question is the recent Tamil Nadu.
That's right. Governor Ravi did not read the speech given by the state government. He read another speech.
Where he was patently wrong. He was not justified in doing that. And I'll explain why. Now, Article 176 of the Constitution says special address by the governor. So this is of a different character from Article 175. Now, here it says at the commencement of the final session of after each general election to the Legislative Assembly and at the commencement of the first session of each year. So this was the first session of this year. The governor shall address the Legislative Assembly, or in the case of the state having a legislative council, both houses assembled together and inform the legislature of the causes of its summons as to why it's been called. Second is very important, 176.2, subclause 2. Provision shall be made by the rules regulating the procedure of the House or either House for the allotment of time for discussion of the matters referred to in such address. The Constitution makes a specific provision asking each legislature to make provision for a debate on the President's address. So the importance and sanctity of this address is of a totally different order. This is an address where the government of the day sets forth its agenda, of course, pats itself back on its back for its achievements and lays out its agenda, and then it is required to be debated. And if it is adopted, it is an affirmation of the majority of the government. If it is defeated, if a motion of thanks to the governor is defeated, the government resigns because it is a lack of confidence in the government. So this is the importance of this address. And here, the governor had no business to refuse to read portions or to say something of his own.
I presume you're talking about the Tamil Nadu case, which you can perhaps explain for those who may have missed it.
Yes. So we understand from what we have read that the address prepared by the Tamil Nadu government, which had already been sent to the governor in advance, spoke about the Dravidian model of governance, which is something in which all Dravidian parties take pride, whether it's the DMK or the AIADMK and their allies. Dravidian model of governance, and it made reference to tall leaders of the Dravidian movement like C.N. Annadurai and Karunanidhi, apart from icons like Kamaraj and also Dr. B.R. Ambedkar. Now, there was the reference to those was in the context of the government showing its inspiration for how it has governed and how it seeks to govern. Now, to drop those references altogether was completely out of order. There's a different situation if the governor, because of ill health, is unable to go on with the whole speech. Then he or she may say, the speech is before you, the rest of my speech is taken as read. I've read out the salient paragraphs, which means the speech is adopted by the governor, but for some reason of convenience, the whole speech is not read out. But you can't excise portions of the speech. You can't be an editor of a government speech. And if I remember right, in that speech, he referred to Tamil Nadu as Tamilagam. Now, that was also something impermissible. The state has a name, and here this is a name which the state gave to itself in the late 60s. It abandoned the colonial name of Madras. Resolutions were passed by the State Assembly and the Council adopting the name Tamil Nadu. Parliament took note of the resolution. Parliament has passed a law to amend the relevant schedules of the Constitution to name the state Tamil Nadu. Now, just because you think Tamilagam is a nicer name or a more appropriate name, sitting in the position of a governor, it is impertinent to make a suggestion like that. He has offered some kind of a clarification apparently today. You may find that on the net, which I couldn't understand at all. He says, far be it from me to suggest that the state should be renamed But I think he wanted to create some kind of a link between Kashi, because now there is this Tamil Sangamam there, and how this land was known as Tamilagam. Tamilagam is the home of Tamil. Tamil Nadu is the land of Tamils. And I think, even if he doesn't say so, his objection was to Nadu as land, meaning that land means country, and that connotes separate nation. But then let's think about it. You know, the Coimbatore area is called Kongu Nadu. So will we rename the Coimbatore region as something else? Or take your state of Maharashtra. You have Khandesh. So is that a Desh? So I don't think one should be so suspicious about the meanings of traditional names. And here, I think the governor has either shown his insecurity or is thinking or has his own agenda. But I'm sure his saying so has embarrassed the party at the center which sent him there.
Yes, though of course he belongs to no party, that's the convention. This kind of, and it has created bad blood between the government and the governor, clearly.
Yeah. Yes.
This kind of bad blood we saw in Kerala with
Yes.
Governor Arif Mohammad Khan and the government,
Yes.
the CPM government, and he was being quite, shall we say, vocal
Vocal.
in
He was being offensive. He was being offensive, but yes.
well, offensive, yes. And the current vice president, Mr. Dhankar, when he was the governor in West Bengal, was always at odds with Mamata Banerjee.
Yes, I think he was quite a pioneer in this recent round of
Correct.
confrontational governors.
Very much so. Very much so. I think he set the tone.
That's right.
And then Mr. Koshyari, who was in conflict with the Uddhav Thackeray government.
Yes.
Plus, as it happens, the governor of Maharashtra also made 3 or 4 contentious statements, which no party has liked and had to, make its displeasure known.
Absolutely.
So we are talking about these 4 instances at the moment. There may or may not be more.
Why are you forgetting about Telangana?
Oh,
Also
Telangana.
fairly recent. And of course, Lieutenant Governor of Delhi, who's a different kind of governor. We are not talking of the big governors, but they all seem to have made it their agenda to make life as difficult as possible for the incumbent chief, for the government.
Yeah. Being a journalist and not being constrained by so many other factors, I might offer also another perspective is that all these governments that you mentioned happen to be opposition to the BJP.
That's right. That's right.
So am I jumping to conclusions by looking at it as a pattern?
Well, it definitely has a pattern. But I must say that there have been certain individuals, and complaints about partisanship of governors date back to the Congress days. So this is not something entirely new. But there have been many instances of constitutionally correct governors who, in spite of their allegiances, have not crossed the line. I'll give you 2 fairly recent examples. MC Bhandare was the governor of Orissa when the Congress was in power. And he had a perfect working relationship with Naveen Patnaik. And even more recently, when Ramnath Kovind, before he became president, when he was governor of Bihar, and Nitish Kumar, that was his first break and his first alliance with the RJD. So in that phase, when Nitish Kumar was not in alliance with the BJP, he had a very cordial relationship with Governor Ramnath Kovind and publicly acknowledged it. So there can be individuals. And similarly, this of course goes back to the early part of the century. There was a former Chief Justice, Justice Rama Joyce, who was Chief Justice of the Punjab and Haryana High Court. As a lawyer, he had been an RSSite. He was lawyer for Advani and Vajpayee when they were detained in Bangalore. He became a judge. As a judge, his conduct was exemplary. Nobody could find fault with him or accuse him of showing allegiance to his ideological mentors. Similarly, when he was sent as a governor, he was governor of both Jharkhand and Bihar. Jharkhand had BJP chief ministers at the relevant time, but when he was governor of Bihar, the chief minister was Rabdi Devi. And he promised that he would be a textbook governor, and he was. So individuals can make a difference.
No. So at the moment we are seeing in recent history, in the last 5 years, shall we say, or 6 years, cases of governors being provocative.
Yes.
And you've just mentioned several of them, including the Lieutenant Governor of Delhi, who, no matter who that person is, seems to be on
That's
loggerheads
right.
with Arvind
That's
Kejriwal.
right.
So the common factor there is Kejriwal,
Kejriwal.
if I may just
Yeah,
make
that's
a.
true. Yeah,
But you mentioned that there have been cases of rogue governors, if I can call them rogue governors,
yes.
like Bhutta Singh in Bihar, who actually
Yes.
got the government dismissed.
Yes.
Ramlal in NTR.
Andhra Pradesh, that's right.
Andhra Pradesh, the
Yes.
chief minister was away for a medical surgery or something, and then he got the government dismissed
Yes, that's right.
and installed a puppet, more or less, Bhaskar Rao. But was it at the same time so rampant? Do you ever recall a situation? Six of them or five of them or something?
No, I don't. No. Honestly, and perhaps I don't think there was a sort of coalescence of obdurate governors or rogue governors or, governors who were transgressing the line. I don't think 5 or 6 of them happened together.
And all these governors happen to be members of the party which is in Delhi?
Yes, if you go back to...
Except for Delhi, because they are administrators.
Yeah, that's right. You're talking now of the current governors, or are you talking about
current
past instances? Yes, current, of course, whether it's Telangana
or Kerala,
right? West Bengal, Maharashtra,
and now Tamil Nadu.
And now Tamil Nadu. But he's not a member of the party, no.
Oh.
He was an intelligence officer sent by the government, which is really a BJP government, but he was not a member of the BJP government.
So,
but you can be more loyal than the king.
That is true.
Yeah.
You mentioned that he must be embarrassing the BJP.
Yes.
So he's perhaps playing his own games of grandeur.
It's quite possible that he has delusions of grandeur.
To conclude this part, but I just want to say that could they be building a case that the legitimately elected state governments are incompetent? Because in the West Bengal case, there was this narrative constantly being peddled around immediately after the elections where Mamata Banerjee won really well, handsomely.
That's right.
That was a violent state and there were riots and could be dismissed and president's rule can be established.
Yes.
Is that something that could be created?
Yes, they could be creating that myth, but I don't think they can be so foolish today as to attempt dismissal of governments enjoying clear majority, because we are not in the 50s where Indira Gandhi could ask her father to just get rid of the MS Namboodiripad government in Kerala. Today, after the Supreme Court's judgment in Bommai's case, imposition of president's rule is subject to judicial review. And the court has said, and it has done so also in the Arunachal case, for instance, it can set the clock back. It can reinstate governments which have been illegitimately removed. So I don't think they can easily do this, but it is possible to make life miserable for state governments.
And keep the pot boiling, as it were.
That's right.
Just to wind this up, Governor Ramlal was dismissed by Gyani Zail Singh.
That's right.
So the president, if she wants, can, and if there is a complaint and she feels, can recall the governor.
Recall, yes. Kiran Bedi, when she was an embarrassment in Puducherry, she was quietly recalled. Very recently, she was quietly recalled.
Absolutely. Now, coming to other constitutional posts, which are supposed to be independent, do you think that they are susceptible to pressure from the government of the day? Because, a lot of questions were raised about the impartiality and the fairness of election commissioners in recent times.
Yes, definitely, as far as the Election Commission is concerned.
And even earlier, if I recall, once or twice.
Absolutely. And that's why the Supreme Court is dealing with a case. A constitution bench is dealing with a case which asks for a collegium-like system for appointments of election commissioners. Now, for instance, if a CBI director has to be appointed by a panel consisting of the Chief Justice of India sitting with the Prime Minister and the leader of the opposition, there must be a similar system, institution as important as the Election Commission.
Yes, that case is being heard. You're right. Mr. Qureshi was with us recently,
That's right.
and he put that matter into perspective. But there is another, what I would think is an alarming, not tendency, but an alarming thing that has happened in my view. The Mr. Dhankar, the vice president, has made a statement dismissing the famous Kesavananda Bharti case, 1973, which established once and for all that the basic structure of the constitution was sacrosanct.
Well,
Of course, on January 26th, we will also celebrate the coming to force of our constitution. But this is what Mr. Dhankar has said is because it's an established law and an established, everyone swears by the Kesavananda Bharti case. But Mr. Dhankar's statement is somewhat dangerous, isn't it? Because that could open the way to change the constitution.
well, Siddharth, let me make a disclosure first. I am a critic of the basic structure doctrine, and my essay criticizing the basic structure doctrine has been carried in a volume produced by the Supreme Court itself to commemorate its 50 years, because the volume was titled Supreme but Not Infallible Essays in Honor of the Supreme Court. And one of the essays was a critique of the basic structure doctrine. So I don't think it is sacrilege to question the Keshavananda Bharti judgment. It has serious conceptual issues. But as I argued in that essay, and as I will argue now, it is that imperfect constitutional doctrine which in the 70s saved the country from the perils of brute majoritarianism, which was of the Congress era. I had naively expressed the hope that those days are past, that coalitions are the order of the day, the country can only be governed by consensus, and so the doctrine must be buried. But now, again, we have the days of brute majorities, and so this is not the time to raise the issue of the basic structure. Of course, the vice president would, and of course, I'm sure the government would. But today, I would say, thank God the basic structure doctrine is still in place, because if there is a pernicious attempt to destroy a basic feature, if it's secularism, for instance, then the basic structure doctrine is what will come to the rescue of the country.
Well, in the 90s, 96, 97, we had two coalitions, one after the other, neither lasted. Before that, we had PP Singh and Chandrasekhar. So there was a time when coalitions looked very, very possible. And in fact,
Even Narasimha Rao time, even the Narasimha Rao time was
even Narasimha time.
That's right.
And Mr. Vajpayee was...
maybe even Vajpayee won. Yeah, that's right.
Yes.
That's
Yeah.
right.
But I'm impressed that you are admitting that sometimes your views also could have been wrong in that particular, in today's context. But
Yes.
it's the fact of the constitution. The layperson, the lay citizen does not know the ins and outs of the doctrine.
That's right.
The constitution is a source of great, great comfort to minorities,
Yes.
to the underprivileged, I take there, and to every citizen, even
Yes,
to
that's-
even to somebody who may belong to a privileged class. The fact that the rights are in place is a matter of great comfort.
Yes. Indeed.
Why tinker with it, or why in fact destroy it?
There's a difference between tinkering and destroying.
Well, tinkering can
Constitution-
lead to destroying.
The Constitution, with its provision for amendment, permits tinkering, and that's necessary because no generation has a monopoly of wisdom, as the great Justice Khanna said. And therefore, there has to be room for play in the joints. It's not an immutable document. But its essential features ought not to be destroyed,
Such as,
a republican form of government. Now, can you cite the popular will embodied in a brute majority in parliament and say that this is the people's will that India shall become a constitutional monarchy? No. Can you say India shall become a Hindu Rashtra? No. Can you say that those who do not profess a particular faith, the Hindu faith, shall not have the full rights of citizenship which Hindus can have, which militates apart from secularism, at an essential tenet of our constitution, which is equality. So some of these, I believe, are immutable. On the other hand, let's say, okay, democracy is a basic feature of the constitution. But is it the parliamentary form of democracy which is basic to our constitution? Because there can be a serious debate. And there have been debates in the past. The late Nani Palkhiwala was a proponent of the presidential form of government. Yes. Now, it will be a test of the basic structure doctrine, of the basic structure test, to see whether a switchover to a presidential form of government falls foul of the basic structure doctrine.
Or proportional representation.
Or proportional representation. That's right. That's right.
Yeah. But the current form of democracy means if there are 4 candidates in your constituency,
yes, first past the post,
and you get 26%,
yes,
you could win.
That's right. And that's incongruous. It's unfair in so many ways.
So
that's right. So that's a good example you gave. Now, if we do away with the first past the post system and opt for a system of proportional representation, would that be destructive of a basic feature? That's a moot question.
Yeah, but that also suggests that, I don't know. I think it's just been with the new constitution of South Africa when it was liberated after apartheid came in for proportional representation. And there is a lot of criticism of that. And of course, there can be criticism of a lot of things. But would you not rather fine tune this in some way or improve it than radically overhaul it?
Yes, of course. It's better to proceed in stages than to overthrow the constitution. Our neighbor, Pakistan, has had several constitutions. And of course, their judiciary, from time to time, has devised novel doctrines to justify different military coups. The first was the doctrine of revolutionary legality, that the revolution itself furnishes the legality for the new constitution. And then, in the 70s, was the doctrine of state necessity, which said that sometimes, for the sake of survival of the state, the constitution needs to be put in abeyance. We are not, fortunately, anywhere there.
But I have read about it of the period of the 70s when Jayaprakash Narayan and others were talking about partyless
total revolution and
total revolution, partyless democracy. General Ayub Khan were talking about something similar. Partyless
yes, he spoke about basic democracy. Ayub Khan's doctrine was a basic democracy.
Yeah, so I find that whenever there is room for improvement, when somebody comes and says, I think let us debate the room for improvement, it's usually close to kind of changing a lot of things around it.
Yes.
And for somebody whose family depends on reservations, for example,
yes, that's right.
It could mean, the difference between livelihood and back to the same old grind. And people have benefited from reservations.
That's right.
I would personally profess a little bit of suspicion about these matters. But you are the lawyer and a constitutional lawyer in the Supreme Court. So obviously, you see it from many other points of view.
That's right.
I speak as a citizen. Many things have worked really well. Many things have not. Always, as we have been discussing, we can look at them, reevaluate them, perhaps suggest how best to optimize our republic. The Constitution, as you said, is one of the finest in the world. So the republic could also be in synchronicity with the Constitution and be a fine republic.
Yes.
Where do you see us as an observer of the Indian system? Where do you see us 2 years from now? In terms of what will happen to the Constitution, what will happen to the Republic, what will happen to our faith in the Republic?
I'd like to divide these 2 years also into 1 year slots.
Yes.
Till 2024, I don't see any major disturbance. I see these pinpricks happening. I see provocative statements. But I don't think there will be major overhaul. But post 2024, depending on what happens in 2024, 2025, 75 years of the Constitution, what it will look like between April, May 24 and January 25, your guess is as good as mine.
Don't forget that to change these things, you require a two-thirds majority.
Yes.
And we don't know whether that will happen or not.
Yes, that's right.
Even
We
this
don't
year,
know.
even this time in 2019, two-thirds did not happen.
Yes, it didn't.
There had been only one instance of two-thirds.
Yes.
So, but you leave room for the possibility that depending on the verdict into 2024, 7-8 months could be quite crucial.
I think so. Because I'll give you an example from 2019. Article 370 was not touched between 2014 and 2019, but it was soon after the 2019 elections that election promise was implemented.
While it was on their
That's right.
manifesto
For
all the
quite
time.
some time. That's right. That's right.
But that was a swift action. This could
That-
take a whole lot
No,
of.
this is a much. That's right. That was, yes, major overhauling of the constitution can't be swift in the way in which that was.
So all bets are off. So let
Yeah,
us
that's
see
right.
what happens in 2024. Very well said, Raju. You really explained what should be as citizens alert to, while giving us the historic context of where we have reached and how we have reached. But clearly now, if we see governors, as you said, print tricks and needling various state governments, it can't be coincidence. Thank you once again very much for participating in this.
Thank you so much, Sidharth. It's been a great pleasure talking to you.
Yeah, that was Raju Ramchandran, senior lawyer, constitutional expert, and author also. By the way, I have read your book of articles. That superb title. I wish I would have stolen that. And telling us about basic structure of the constitution, the importance of governors being fair players, and trying to analyze, because we all are equally in the dark, trying to understand the whys and wherefores of the way the governors have gone log against state governments, trying to understand what's happening at various states. That's the end of our episode. We'll be back again next week with another guest. Till then, from me, Sidharth Bhatia, and the rest of the Wire Talks team, it's goodbye. You can check out this podcast and other interesting ones on the Wire website, the IVM podcast website, app, or wherever else that you get your podcasts. Goodbye from me, Sidharth Bhatia, and the Wire Talks podcast team.